every factor here has consequences to the contract. It either makes the contract valid, void, or voidable. When you're answering a question in contract law, and we're going to go into details with this when we do the contract law examination recording. I am going to go through one or two examination papers where we are going to go through the answers of that examination paper. So for when you're answering a contract question, just for me to make the point, the first thing you do is identify the topic. Identify what topic it is. Identify the topic. You ask, what is this question asking? Like, which topic does it belong to? And then second thing, rules of that topic. You rewrite everything you have in your head about that topic. Every single thing you have in your head about that topic. And then apply to the scenario. So you're applying the rules of that topic, that scenario. You apply how, and this is the final part, your conclusion. By conclusion, you have to state whether that specific contract is void, voidable, or valid, and no, in actual fact, let's do this. Conclusion. So for conclusion, you have state whether that, and then you have remedies according to what the state of the contract is. So this is how you answer a contract law question. And you answer a contract law question by first identifying the topic, rules of that topic, apply to that scenario, and then conclusion, state whether that specific contract is void, voidable, or valid. And this is a very important one because it helps you understand the whole point of contract law as a module. The whole point of contract law is to test, is this pupil able to see that this contract is a void contract? Is it able to differentiate what a void contract is, what a voidable contract is, and what a valid contract is? And is it able to understand how, in your cases, how consensus and contractual capacity affects the state of the contract? Does it make the contract void? Does it make the contract voidable, or does it make the contract valid? So that's the whole point of contract law. Are you able to identify? So in every scenario that you get, in contract law, they will say that X and Y entered into a contract. This is what happened, but X is refusing to do his part and stuff like that. So what happens now? Or let's say X is a 13-year-old. He entered into a contract with a 25-year-old, and then 25-year-old wants to sue the 13-year-old because he didn't do his part. The question is based on what you understand about contractual capacity. Based on what you understand about contractual capacity, is this contract void, voidable, or valid? Because you are only able to get certain remedies from the certain state of the contract. Like in that scenario that I gave you, the topic there is contractual capacity because it's a 13-year-old who entered into a contract. The rules of contractual capacity is that a minor is not allowed to get into a contract without the consent of a guardian. That's the rule of contractual capacity. And you know that And in the scenario, it states that there wasn't a guardian who consented to the contract. So you are able to say that, okay, in the scenario, there is no mention of an adult who consented. I don't even know if that's a word, consented to the contract. Therefore, and this is where your conclusion comes in, the contract is void. And therefore, the remedies available to the 25-year-old is only the remedies, no, sorry, not actually void, but it's voidable. Don't worry, I'll explain later. It's voidable. Contract is voidable. The remedies available to the 25-year-old is that of delict and not contract law. That's it. So that's how you answer. Now you see that the core, your understanding of how to approach a scenario depends on your understanding of what the whole point of a contract law question is. A contract law question is it's testing whether you are able to identify what state does this contract exist in because of that element that is required in that that is stated in that scenario. But we'll get through this more and more. I just wanted to illustrate that this void, voidable, and valid is the most important elements of a contract. I mean, of your contract law module. So these three factors create consequences, and the consequences are in the following categories. Does the contract exist? Was there an agreement that existed? Is it legally enforceable? Were obligations created, rights and duties that need to be performed? Is it possible to fix it and to make it enforceable? So first of all, each state talks on, does the contract exist? Is there an existence of contract? Yes or no? Does the contract exist? Was there an agreement that existed? So does the contract exist? Number one, did the parties agree on something? Did the parties reach consensus, which is the second question? Was there an agreement? Was there a valid agreement that existed? Is it legally enforceable? So can I force someone to use this contract? Like in the scenario that we did above, I'm not able to enforce that contract because that contract is a voidable contract. I'm not able to enforce it. And then were obligations created, meaning were rights and duties, are there certain rights and duties that need to be performed, like we discussed here? If a contract exists, if a contract shows there was an agreement that existed, if a contract is legally enforceable, then it means that the rights and duties, they need to be performed. It's a must. You can't avoid them. But if it's an invalid contract, then these rights and duties basically don't exist, meaning that you don't need to perform them. Lastly, is it possible to fix it, to make it enforceable? There's a certain state that allows you to make it enforceable. So a void contract implies that there is no contract. That's what a void contract implies. It doesn't even imply. There is no contract that exists. Leave the imply. There is no contract that exists. It's void. Doesn't exist at all. Meaning that everything is in the negative as well. There is no agreement between the parties. It's not legally enforceable. Starting from the time it was created, there were no obligations created and no parties required to carry out any of the obligation, and it's not possible to enforce it at all. You can't fix it to make it possible. So that's a void contract. So when you're explaining a void contract, this is how you're supposed to explain using the terminology that I used here in these notes here. There is no contract that exists. is no agreement between the parties. It's not legally enforceable starting from the time it was created, when no obligations were created and no party is required to carry out any obligations, and it's not possible to enforce it. So you see the word obligations coming in again, and you know that obligation just means the rights and duties were not created, meaning that the parties, party A and party B, they don't need to carry out any obligations. Okay. And then we move to avoidable contract. Avoidable contract says that contracts does exist at the expense of the aggrieved party, meaning the aggrieved party is given the power to decide whether to enforce or set aside the contract. So this is the one that says, this is the only one that says it's possible to fix it and make it enforceable. And the only way you can fix it is at the expense of the aggrieved party, meaning that you usually lack permission to conclude it. And that's why you see in the scenario that we did about the boy who was 13 years old, who entered into a contract with a 25-year-old, it's avoidable contract because they can fix it. How can they fix it? The parent can consent. The parent can give that last permission. So under avoidable contract, it usually lacks one permission. And you'll see how we do that. The contract lacks a final one permission. And you see what I mean by that. It lacks a final one permission. It just needs one more person's permission for it to be valid, and then it's valid. So in that case that I showed you, the 13-year-old who entered into 25-year-old, 13 minors are supposed to have, a parent consent to their contracts unless they're an emancipated minor, obviously, but that's something that we'll get to when we do contractual capacity. But just want to say that for that contract to become, it's a voidable contract as it is, but for it to become valid, it needs the consent of that guardian's parent. So when the guardian says that, okay, I'm going to consent to this contract, it means that now the contract is enforceable. Now the contract is a valid contract, which we'll get into. So a contract does not exist at the expense of the aggrieved party, and usually, like when we do duress, you'll be able to see what I mean by aggrieved party. The aggrieved party is also another person who can give the final level of permission. Like if you were forced to get into a contract, that contract is not void. That contract is voidable. But you can make that contract a valid contract by the person who was forced to enter into that contract. That person can give permission. So again, it lacks one final person's permission, and that person's permission can come from a guardian. It can come from an aggrieved party as well. But we'll get into it when we really discuss contractual capacity and consensus, because that's where you really see the different states of a contract coming into play. But avoidable contract means that it's only enforceable if the aggrieved party makes it valid. No obligations exist until the aggrieved party makes it valid. So avoidable contract is more of, it's not finished. We're not done. Everything is